Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville workers' compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. And friends, welcome back. We're in the studio here with Scott Scheynost, esteemed Louisville workers' compensation attorney. Scott, how you been, guy?
Pretty good. Good to see you again, Jim.
Glad to see you. In fact, we're going to talk about something that's kind of interesting today. It's how to be the perfect workers' comp client. You've only done this for a few years.
This is
right?
on my wish list. Yes, yes.
So how long have you been practicing workers' comp here in Louisville?
Oh, these are hard questions. Gosh, 35 years coming up.
Yeah, coming up. You've handled a lot of these claims. You've dealt with a lot of situations, and just like any other court, case, there are certain things a client can do to either make it easier or to make it more difficult. And today we're going to give some helpful tips about what you can do to actually make your claim go just a little bit easier.
Yeah, I was thinking about this today. I was thinking about what would make my life easier, but in a sense, I think it would make the claimant's life a lot easier too. So I'm happy to talk about this subject.
Well, let's start off with the rule number one in Kentucky workers' comp is you've got to notify the company that you've been injured, right?
Right. Assuming that you're not bleeding to death and don't have to have a tourniquet placed on you and the jaws of life to remove you from a car, the first thing you're required to do is put your employer on notice that you had an injury. And the obvious things where you've been run over by a forklift or something like that and your boss sees you, that's enough notification. But a lot of times people are working by themselves. Sometimes people have an injury that they don't think is a big deal, and 2-3 days later, it is a big deal. They hurt their back, and they worked through it before, but all of a sudden they can't. So in those situations, the law requires that they put their employer on notice as soon as possible about the injury.
And that does not mean telling a colleague or a coworker. That means you've got to tell a supervisor or somebody kind of up the food chain, right?
Correct. An employer is considered to be a supervisor, manager, somebody in a position above you that has some kind of managerial control over you. The law actually says that the notice has to be in writing, but that's not as strict as it's been interpreted. Just tell your boss or supervisor you got hurt. Sometimes it's a good idea to write that down on your own diary if you got it, on your calendar, and or we got, I guess, a watch we can put it into even.
Well, and it's, yeah. I think later on in the podcast we're going to come back to talking about the documentation, and,
right.
And it's this is a good time to get it started. Hey, I talked to so-and-so on this date and inform them that basically I got hurt, right?
Right, yeah, and that comes up every now and then, especially with employers that move around a lot. I'm talking about the employers moving around a lot. You may go from one job site to another job site to help somebody. You may have a different supervisor. Sometimes people get lost in the shuffle. But it's important to put your employer on notice of the injury as soon as you can. And again, it's also important to document that somewhere on your own system. If you've got a watch, if you've got a phone where you get entered into, if you've got a calendar at home, if you got a buddy that's there that can write it down too, that saw you tell the supervisor it happened, all that stuff can be important because we may end up arguing about that later on.
Well, that makes sense. You could send yourself a text, you could leave yourself a voicemail, you could send yourself an email, right? All those things. Just ways to make life easy.
Correct.
The other thing is it deals with who else might have been around when the injury happened, right? The witnesses.
Witnesses are important sometimes, especially depending on the injury. I've got a case right now. Looks like we're going to be arguing about what the witnesses saw and when they saw it, things like that. So it's important to keep track of all the people that were there that saw it. It's important to find out where they may be down the road. People change jobs, quit, move on. Different places are different with the number of people that move around. Some people have a lot of turnover, some don't, but it's important to keep track of all the folks that saw the injury. If you know who they are, if you've got their names, we can eventually track them down. Your employer's paying them. Your employer's got a record of who they are with Social Security numbers, and if you know who they are, we can eventually get that information from the employer. But it's also important for you to remember who it was. Write it down. Write down what they saw, what they may have heard, what they may have said to other people. All that stuff can be very important. And essentially, again, what we're doing is we're documenting our case to show that you actually did get hurt at work. So sometimes that's an argument, sometimes it's not. If it's not an argument, great. If it is, you're prepared for it.
That makes a lot of sense. Is it like what you see on TV where they might be called up in front of, in court somewhere and sit in the witness chair and be asked about this? I mean, workers' comp's a little different, isn't it?
Yeah, no, it can be like that. I mean, it can be a disputed case where you actually bring people in to testify about those kind of things. Most of the time, though, what we're going to do is we're going to get somebody to verify that. We'll get them to sign a statement saying they saw this happen. Hopefully, we'll be able to do that in front of a notary, and then it's an affidavit, and it can be admitted a little bit later on if we have to. And usually in workers' comp, that's all we have to do. Once we verify that it happened, and we can usually use other things that go on. For instance, if you told your boss about it, that's one reason we do that. And then we're going to talk about this a little bit later on down the road. Medical records become important too. So we'll look at all that stuff. But there is a chance the people that saw it could be called as a witness. That's happened before. But most of the time, once we document it and we can verify it happened and we've got enough evidence, usually the claims adjuster, usually the attorney will go ahead and agree that happened. But it can be something that's disputed, and it can be something where somebody is brought into court and have to testify about it.
That makes sense. Well, so the next step, and you actually did a video on this quite a few years ago, talking about one of the best things you can do for your case is to choose your own doctor. Why is that so important?
Right. In Kentucky, you get to choose the doctor that you want to treat with, and a lot of companies will tell you you've got to go to the company doctor, but that's not the law in Kentucky. It is in other states, for instance, in Indiana, but not in Kentucky. It's important for you to go to your doctor because your doctor usually has your best interests at heart, especially your family doctor. They're not in this to get more clients from the employer. They're not into this to get more clients from the insurance company. They're not into this to get more clients from the plaintiff's attorney. They're usually in this to help you. That's why they're doing this. And they're usually underpaid, and the only reason they're doing it is to help you. So if you can go to your family doctor, that's really a great thing. But even if you can't go to your family doctor, it's important for you to pick out the doctor. Generally, when the insurance company or the employer tells you you've got to go to a doctor, you want to write that name down and try to do everything you can not to see that person, because there's a reason they're steering you to that specific individual. And the best thing you can do for yourself is to pick out a doctor that has your best interests, that wants to help you, that's not interested in getting more referrals, that wants to take care of your particular medical situation and make you better. Generally, when you pick the doctor, that's going to happen. If you're letting somebody else pick the doctor, that's usually not going to happen. There's a reason they're selecting somebody.
Anytime your employer says, "Hey, I got a guy," antenna should go up.
Write that name down and make sure you don't see him if you possibly can.
Yeah.
And most people have had some kind of an injury that's similar to what they've had this situation, or they've had a friend that's had that injury, or they know somebody, and they can make some phone calls and talk to some people and find out some good names. And it's important to have confidence in your doctor. If you don't think your doctor's got your best interest at heart, even if he does, that sometimes has an influence on where everything goes. So if you pick the doctor, number one, it usually helps your case. Number two, it helps you to be in charge of what happens down the road too. And you're not as dependent on what the company's doing and what the insurance company is doing to try to save money on your case. When they steer you to a doctor, they're trying to manage your case from the very beginning. A lot of people don't realize that, but when they tell you to go to a certain doctor, they're trying to reduce their costs from the very beginning of the case. And it's important, number one, that you find somebody that's going to help you and take care of you. But number two, I think your medical treatment will also be better, and you're going to end up with a better result when you pick your own doctor. That's my own personal belief.
Well, I like that you made the statement about you can maintain some level of control in it. And part of that comes from what you're actually telling the doctor about the situation that basically happened from the outset, right? From the point of the injury, right?
Yeah. And another thing, too, about control is in Kentucky, you can pick the doctor, but you only get to pick 2 times before you run into some problems. For instance, if you go to the company doctor and you fill out a certain form, that's your first pick, even though you may not have felt like you've picked it. So if you're not happy with them and go to another doctor, well, you're going to be stuck with that doctor unless something extraordinary happens. So you want to pick your own doctor in case it doesn't work out for whatever reason. He doesn't do that specialty. She doesn't want to mess with it. Then you've got another choice, and you make that other choice relatively easy. And you may even have to make a third choice. But when you go to the company doctor, the insurance company doctor, you've already reduced one of your choices, and it just makes it a lot harder to move around later on if you have to.
Well, that's a really good point. But coming back to the documentation and explaining it, why is it important that you really go into detail about what happened regarding the injury?
That's the next thing when you see the doctor. This is actually one of the more important things in your workers' compensation. And a lot of people don't realize what goes on from the doctor's side of it. Because when you see that doctor, you're going to have all kinds of forms generated. You're going to have x-rays made and reports. You're going to be telling the nurses what happened. You're going to be telling the doctor what happened. And every time they write something down on a piece of paper, that becomes part of your medical record. And the claims adjusters and the attorneys and the administrative law judges will end up going through those records with a fine-tooth comb. So one of the very first things you need to do is you need to make sure you give those medical professionals the correct history. And what's a history? History is what happened to you. How did you end up with this particular medical condition? Did the forklift run into you? Did you get hurt playing basketball? Was this an old injury that's been nagging you for 5 years? When you go in and you tell the doctor, the medical professional, the nurse, even the receptionist what happened, they're going to make a record of that. And that's going to be permanently in your workers' comp claim. And I've seen cases that I've turned down that I could tell we're not going to go down the road very far, because when somebody went in, the very first thing they said was, this is an old injury. It's been bothering me for 20 years. Sometimes we can get around that as an attorney depending on what kind of work they had and what was going on. But when you start mentioning things other than a specific accident at work, that creates a bad history that has to be explained. Sometimes we can explain it, sometimes we can't. But giving the doctor an accurate history about what happened is very important. Number one, the claims adjuster is going to look at it to decide whether or not you got hurt at work. So they're going to go through your medical records to determine what's going on. Number two, the doctor you see that day may not remember your face 5 years from now when we ask him, how did you get hurt and whether or not it's work-related. That doctor is usually just going to go back and look at your history. And a lot of times I'm in a deposition with a doctor and I say, doctor, we're arguing about whether or not somebody got hurt. And the first thing the doctor says, they might see 50 people a day, 5 days a week. And the first thing the doctor's going to say, well, let me look at my notes. Let's see what the history said from the very first day that you came in. So 5 years later, what you say that very first day you see the doctor becomes real important, because that treating doctor, who's the judge is going to put a whole lot more weight on their opinion than the doctor I hire or the doctor the insurance company hires. But the treating doctor's history about how you get injured is going to be the very first thing they look at to see if it's work-related, and that's going to help or hurt your case from that point on. So when you go into the doctor the very first time, what you tell them is vitally important, to be accurate, to let them know you got hurt at work, to let them know what parts of your body got hurt at work, to let them know how you're doing right now. That's just hugely important. And a lot of people don't realize that. They just go to the doctor to get better. Well, that has an impact, and it could impact your case greatly depending on what you say and how you say it. So be very careful, be accurate, and let the doctor know exactly what happened. If you got hurt at work, make sure they know it got hurt at work.
Absolutely. This is kind of interesting, but it's also something that a lot of people really kind of screw up on. But it's follow the doctor's advice, and get the treatment, complete the care plan.
Yeah, in Kentucky, there's actually some laws that say if you don't follow the doctor's recommendations, it can influence your workers' compensation claim. I'm not going to go down that road right now. But first of all, and we'll go back to this later on, I think the administrative law judges in the system want to help people that want to help themselves. So if the doctor says go to physical therapy, if the doctor says take this medicine, if the doctor says lose some weight, if the doctor says stop smoking, I know a lot of people don't want to do that, but if the doctor says that and you do it, or at least you try to do it, that will carry a lot of weight with a lot of people. I know it's hard to stop smoking. I've not been a smoker, but my family has got smokers in it. And if they recommend stop smoking, at least try to take some of the medicine that might be available to do that. If they recommend losing weight, at least try to do something, exercise, cut down on stuff to try to do that. But follow the doctor's orders. And the more things you do to help yourself, the more it will help your case. Number one, the doctor's usually trying to tell you to do this for a specific reason. You may not want to hear it. Sometimes they tell me stuff I don't want to hear about what I have to do. But there's usually a reason the doctor wants to do that. So it will probably end up making you better if you follow this recommendation.
Go figure.
But if you don't, then you're creating little landmines in this battle that you can be stepped on. And one of the first things that the other attorney is going to do, they're going to say to their doctor, they asked them to lose 20 pounds. They didn't do that. They asked him to go to physical therapy. What I see a lot of times is physical therapy where people don't go to it. And they may miss an appointment. To them it's nothing, but it adds up after a while. It makes it look like you're not serious about it. It makes it look like your injury is not serious. So if you're not following treatment, if you're not following recommendations, if you're not following a certain regimen, if you're not wanting to help yourself, the judges will be a little bit less inclined to help you, I think. And the more things you do to help yourself, the better it's going to be for you, and also the better it's going to be for your workers' compensation claim. So my perfect client will do everything the doctor says, ask the doctor what else they can do, and that makes the doctor happy. And you'll see this down the road too. The doctors at a deposition, when we're asking them impairment ratings and things like that, when they remember a patient, and they remember the patient was doing everything that they asked them to, the doctors want to help you too. And I've seen doctors bend over backwards to really help them in workers' comp claims when they like the patient, when the patient was doing what they said, when the patient was following orders. You're just making friends when you do this stuff. You're not only helping
human nature. It's human nature.
It's human nature. And, the doctors got to battle this all the time. People don't follow the directions. But when they find somebody that really wants to be helped, that follows their instructions, that does what they're saying, and doctors aren't perfect. They can't make everybody completely better all the time. But somebody that's trying to do everything they can, they want to help you too, just like the judges do later on down the road.
Absolutely perfect. Scott, the other thing is hire an attorney, but you don't have to do that at the outset. I mean,
you don't have to.
When we talked about notification, you said, well, as soon as you can.
Yeah.
And with an attorney, hiring an attorney, earlier might be better for you, but it doesn't have to be that day.
No. If you need the tourniquet placed on your leg to stop the bleeding, let's do that before we hire the attorney. But when it's practical, when you have a chance, and it looks like you've got a serious injury, give an attorney a call. Most attorneys in the workers' comp system in Kentucky that do plaintiff's work handle this on a contingency fee basis, which means we don't usually charge you unless we get money for you. So it's usually a free call. It's not being charged by the hour. A lot of these things we're talking about right now, we can kind of go over the very beginning, and we can prevent them from being problems down the road. I can go on and bore you to death with all the things that could happen. But if you talk to an attorney, give them an idea about what's going on, they can generally give you an idea about what you need to be doing too. And if you're not doing something right, well, maybe we can fix it. And it's a lot easier to fix it at the beginning than it is 2-3 years down the road.
I would think so.
And it can take that long for a workers' comp claim. If somebody gets injured, has a surgery, we got to get an impairment rating. It could be a year, 2 years down the road before we know what that is and we can resolve your claim. So we want to make sure the foundation's proper. We want to make sure this house is being built on a good foundation. And the sooner you talk to an attorney, probably the better. Make sure you're okay. Make sure you're not bleeding to death. But give us a call when you have a chance, and we'll be happy to talk to you. If it's too soon, we'll tell you. But again, it's usually advice that's going to help you down the road with your case.
Makes a lot of sense. There's information about the claim itself that you really ought to be sure that you communicate consistently, right?
Yeah. In Kentucky, the medical providers will end up billing the workers' comp carrier. Well, to do that, they're going to need to know who to send the bill to. So you're going to need to know some information about the workers' comp carrier. The magic key in almost all these cases is your claim number with the workers' comp carrier. So you're going to need to know that claim number, the carrier's name. It helps to know the adjuster that's been assigned to your case. Those can change a whole lot depending on the carrier you're with. And then the contact information, for instance, the mailing address, the fax number, things like that for the adjuster. You're going to find out that all the providers you see, the doctors, the radiologists, the physical therapists, the pharmacy, they're going to want to bill somebody. So you're going to need that information to make them happy if you want to continue getting treatment and make yourself better. So at some point, you're going to need all that stuff, and you want to write it down, make sure you have it. You'll have to regurgitate it probably every time you go somewhere else. If you get referred, like from a doctor to MRI place, or you get to physical therapy, they need all that information. So try to get the information accurate. Try to get the information, put it in your wallet. In case you've got to pull it out somewhere. It's almost like a health insurance card.
Yep. In
Kentucky, they're actually required, the employer's workers' comp carrier is required to send you something that looks like a health insurance card, but I rarely see that happening.
Okay.
So, this is something that you need to take care of on your own. Otherwise, you're going to get bills. You call me and say, Scott, where's the bill coming from? Well, we'll send this to the adjuster. You get 3 or 4 more letters. The adjuster's going to get the medical records. It takes a while to get it done. You're getting calls from the credit agency. We'll eventually get it taken care of, but there's things that have to be done. If you have the claims adjuster's name and information, a lot of times you'll bypass all that stuff. It's just one less headache to mess with.
That's great advice. When you're talking about the bills, from time to time, you're going to incur some expenses with your treatment. In Kentucky, you can be compensated or reimbursed for the mileage from your home to the doctor and back.
Mileage is considered a medical expense, and the employer is responsible for all medical expenses But there's been some changes in Kentucky law here recently. Essentially, you've got to turn those expenses in within 45 days. Hopefully that law will be changed. There's some arguments that maybe the 45-day rule doesn't apply. It didn't used to apply up until about 2 years ago, but now it does, it seems like. I think the prudent thing to be is if you have any expenses related to the workers' compensation claim is to turn those in within 45 days.
Is there a form they need to use?
There's actually a Form 114. You can download that from the Department of Workers' Claims website that you use for that. We have it in our office. One really good piece of advice I can give you about that is make sure you keep a copy of it and something that shows the date you mailed it to the adjuster, because they miraculously lose most of them. And you have to call them 3 or 4 times. I never got it. Well, here's a copy of the fax cover sheet where we faxed it to you on June 13th, 2023. Well, we never got it. Well, we sent it to you. This is your fax number. You can tell I've done this before.
Yes.
But you got to keep a record of it, too, because typically the adjuster doesn't want to mess with a mileage expense. It's not as much as a $5,000 doctor's bill, so they put it at the bottom of the pile. They figure they can put you off a little bit more sometimes than others. Now, some adjusters are real good about getting those paid, but my experience has been probably about 75% of them don't want to mess with them because they've got to not only pay you, but they also got to verify the expenses, which means if you've got 20 mileage trips, they got to go back to make sure the right amount's been written down. They got to verify that with a date of treatment, and it's a lot of work for the adjuster. So I can understand why they're not too happy about doing it. At the same time, you're entitled to it.
Well, for instance, you may have to go out of town to go see a specialist. You may have an overnight. You may have some meals along the way.
That's
and
stuff
stuff
that
like
can be,
that.
yeah. And a lot of folks don't live in metropolitan Louisville. If you're living out in Bardstown, it's a 40-mile drive one way. So, you're talking about a good chunk of change just seeing a doctor or going to physical therapy if you've got to go to Louisville for that. So, and obviously it can be even more. I think I had one client, we got him $5,000 or $6,000 in past due mileage expense because he never wrote it down before they changed the law. And he was driving about 75 miles one way for treatment 2 or 3 times a week.
Wow.
It can add up. You got to keep track of it. I have some people live right next door to physical therapy. They don't want to mess with it. I can understand that. It's your money, though. And again, this stuff can add up real fast. You get reimbursed essentially at the state mileage rate, which I think is about 43 cents a mile right now.
Okay.
The same rate that the state employees get reimbursed if they're on a trip.
Okay.
So, if you want to get reimbursed for it, you've got to keep track of it. And again, there's been this little quirk in the legal system where you have to turn it in within 45 days. And then also, like I said, keep track of it because the adjusters don't seem to have that as their highest priority about reimbursing that. I've typically talked to 2 or 3 adjusters a month about trying to get somebody repaid.
And like you said, it's your money.
It's your money.
Friends, we're in the studio with workers' compensation attorney Scott Scheynost, and we're talking about advice to help you become the best, or should I say the perfect workers' comp client, And this is just a guy that's practiced workers' comp for 35 years, giving you some perspectives on things you can do to actually help your claim. Scott, let's return to this conversation and talk about social media, Facebook and things like that.
I hate social media for my clients. The first thing that happens if you get injured and the claims adjuster has an iffy feeling about your cases, they're going to type your name into Facebook or Instagram or Twitter or whatever the social media app of the day is, TikTok, I don't know. But whatever you've ever put on there, they're going to see. And not only what they're going to see is what you put on there, they're also going to see what your spouse put on there, what your children put on there, what your niece, nephew, brother, aunt, and uncle put on there. So if you're at a party where, you hurt your leg and you're lying there, literally lying there on a recliner, drinking an alcoholic beverage, and that gets put on social media, the first thing that adjuster is going to say is they're not hurt. How dare they enjoy themselves while they're hurt? Even though you're not doing anything that violates any doctor's restrictions, but this has actually happened to me in a couple cases. It just infuriates the adjuster that you're actually enjoying your life when you should be hurting or having to pay you money for being off work. And they think a whole bunch of things. And, that's just human nature to think that stuff. But at the same time, if you stay off social media, if all your relatives stay off social media, that's one less thing that we have to argue about. Now, the other side of that is when you decide to go to Florida and you jump into the ocean and there's pictures of you jumping into the ocean and maybe, you hurt your arm and your arm's actually not hurt too bad, but you can do this. But just the fact that you're doing some kind of activity would just send off a lot of people. And if you don't have anything on social media, you avoid all that stuff.
That's good advice in many cases involving the law.
Yeah.
It's not, social media is a good thing, but Not when you have a case. It's better just to go mute for a little while.
And the worst part I think about that is when people start piling on to different things where they start talking about their prior workers' comp claim, and then everybody's trying to make their case bigger or better. And
Here we go. Well, there's some wisdom in this one. Let your attorney speak for you.
Workers' compensation is infuriating. There's nothing enjoyable, I think, about the workers' comp system. You're hurt. You're dealing with folks, attorneys, adjusters, safety inspectors that you've never dealt with before. You're not getting any money for being off work. You're trying to get to the doctor. Things just make you mad. Sometimes you have a right to be mad because sometimes people are dragging their feet. But it's better to let your attorney talk to these people in a professional way, because you may end up having the same claims adjuster as jerking you around for the next 5 years. You may have to file a claim. You may have to get an attorney involved in this who is dealing with another attorney who's actually getting their directions from the claims adjuster. And that claims adjuster is deciding whether or not we're going to appeal this decision that we lost. And that claims adjuster is going to have to explain to their boss why all this stuff happened. It doesn't help to make people mad at you. My thought is you treat people the way you would want to be treated, even when they're not treating you the way you want to be treated. If you act businesslike and professional, generally things will work out a little bit better for you. I try to do that when I communicate with the other attorneys and the claims adjusters. I may have lost my temper once in a while, but it's always been justified, I thought. But seriously, this can be an aggravating experience. And when people are not treating you right, your first reaction is to holler and scream at them. But that causes other problems down the road. And 2 or 3 years from now, you're wanting to get this case over with. Whether or not you got that $50 check for being off work for 2 days is not as important as it used to be. It's still important. But, if we're talking about a huge 6-figure settlement, that's usually a little bit more important, and we want to get resolved other than that $50 issue that would happen 2 years ago. So if we've created ill will on the other side, if we've created kind of a brick wall that we've got to jump over or tear down now, none of that helps get your case resolved. If we try to be professional with them, generally they're going to be professional with us. There's exceptions to all that stuff. But let your attorney talk for you. If you're going to talk to somebody, I tell people at a deposition, you're there to act in a professional and business-like manner. You may not be treated like that all the time, but you know what? We're going to do our job just like we're supposed to. If there are going to be the people that are going to be upset and yelling and screaming, so be it. But we're going to do our job just like we're going to do our deposition just like we did our job, professional. We're going to try to be treating other people with the way we would be treated, we would want to be treated. And eventually an administrative law judge is going to have to make a decision about your case. And they can usually detect where there's been an undercurrent of this animosity on one side or another. And if it's on the other side, that's probably going to help you. If you've been professional and business-like, that generally helps you in your case. And that gets back to what I was saying earlier. If you help yourself, the judges want to help you too.
Well, and that's a good segue to these next bank of questions here. When we talk about, resist the urge to play games or to cause issues with your boss and your employer.
Yeah, this is the same thing before. You're not being treated right. The boss might be saying you didn't get hurt at work, all this other stuff. There's all kinds of little things that could come up, dealing with adjusters, even the other side's attorney. Sometimes they'll have you see a doctor who's not always the nicest person in the world as an expert opinion. Even now and then you'll have some kind of private investigator outside watching you to see if you're actually hurt. In those situations, it's the same. Be professional. Don't play games with them. Don't sick your dog on a private investigator. I've had some people try to amp up their injuries around these guys when they know they were being videotaped. That doesn't help. You're not proving your case when you do that. You're actually making things worse. It doesn't fit with what you said to the doctor earlier. So now we've got a problem about who's telling the truth, and you're actually helping them out when that happens. Generally, when you're arguing with somebody over all this stuff, if you're not doing it in the right way, we all tend to overemphasize things and probably cause more problems down the road than we need to. So if you don't play games, you don't have to worry about any of that stuff. It's hard to do. And a lot of folks, this is their only workers' comp claim. There's a lot of issues on the line. I'm going to take care of myself down the road, my family. But you know what? Our main objective here is to get the most we can out of it. And if you don't play games, usually that's going to help you.
That makes sense. And This next couple of questions here are going to refer to really how you work with your attorney. There are two big things here. Return the calls, the voicemails that your attorney may leave you, and get your forms in.
Yeah. If I'm calling you, there's usually a reason. And I wish I only had one workers' comp claimant at a time, but we have several. So I've got a pile of paper on my desk, and I start at the top and I work my way down. If I'm trying to call you, I'm trying to work on that particular piece of paper at the top. If you're not there, then I have to put it down at the bottom. And when you call me back, I'm usually on the second or third one down. And I'd love to be able to just wait for you to call me back. And I know people get busy. I do too. This is what I'm talking about, I guess. But if you can get back with me as soon as possible, if you can answer my phone call, that helps your case. Because I work on it then, we get it done, we can move on to the next issue in your case. I don't have somebody else in front of me now that I'm dealing with, and I don't have to re-gear to get back into your case. Same thing about forms, and when I request information from you, if you can respond to that as soon as possible, that's great. Usually there's a reason. I'm not trying to make you waste your time. We actually need information in your case for different things. Sometimes we're trying to get stuff for you. Sometimes we're trying to get stuff together for doctors that are going to see you. Sometimes we're trying to build evidence in your case. But there's usually a reason I'm trying to get this information from you. I'm really not trying to make you just spin your wheels. There's a reason for it. So if you can get this stuff that I request back to me as soon as possible, or whatever attorney you're dealing with as soon as possible, that helps your case.
I could imagine how that would just work better. I mean, they're asking for a reason typically, and they're on your side.
There's a reason. Yes, yeah. There's always a reason.
So these next two, really, it's about having patience with the process and being realistic with the expectations.
Yeah, in workers' comp, like I said before, there's nothing that anybody really enjoys. Workers' comp's always been kind of a slow system. First of all, in workers' comp, we really can't resolve your case till you've reached maximum medical improvement. Now, a lot of times in a car accident case, everybody can guess that, but in workers' comp, we have to wait till you've gone through your medical treatment, which usually means you've had to have surgery, you've had to recover from surgery, recovered from it sufficiently enough to where the doctor says you've reached maximum medical improvement to give you an impairment rating. Usually when that happens, we request that, and it takes another couple months to get that. So just to figure out what your case is worth can take some time. Now, since COVID has hit, things have gotten even longer to get done. People are working from home. Doctors' offices have staff that are working from home doing medical records sometimes. Claims adjusters are working from home. I'll call up one, I'll hear somebody doing dishes or the dog barking or the kids yelling or something, and they've got distractions. So a lot of things have gotten slower, not faster, since COVID. I've seen a lot of adjusters retire. The staffing's gotten less, which means people are handling more cases, which slows down things. So all that adds up. It was a slow system to begin with, and it's probably slowed down a lot over the last 2 years. Hopefully it'll get a little bit faster. But there's not a whole lot of fast things about the workers' comp system. To get it resolved soon, you usually have to take a lot less than your case is worth. And it's just the nature of the system, and I wish it was different. It's hard for other attorneys that don't do workers' comp to understand all this stuff. But we've got to wait till you get done with your treatment, which sometimes can take 5 years. I've got one client that got hurt in 2018. We're still arguing about stuff. They've had multiple surgeries almost every 9 months, and every time they have another surgery, another one's required. So they may not have even reached maximum medical improvement yet. So all this stuff takes time. Usually people are getting benefits, money, and medical treatment during this time, but it just takes time. And then once we get into the system, what we usually try to do is once you've reached maximum medical improvement is try to resolve your case through a settlement, because that's just quicker, easier, and a lot more efficient than having a litigated case. A lot of them we can't get done through settlement, so we have to litigate. If we can't get your case settled, then we have to litigate it, which means we've got to file stuff with the Department of Workers' Claims. We get assigned to a judge. Proof has to be scheduled. The other attorney wants to check things out, which always slows things down, but it's prudent. They've got to do their job too. Usually 6 months to 9 months once we file a case to get it resolved in front of a judge, if nothing else happens. The judge is okay, the judge isn't sick, we don't need extra time to have a doctor do stuff, and doctors want to operate on people, not write reports. So that's kind of a thing that delays things by itself, is waiting for the doctors to respond. But I understand that. They went to medical school to treat people, not to make workers' comp attorneys happy. But it's still something we have to deal with in the system. But it just takes a while. Is what it boils down to.
And so patience and having the right expectations about what's going to really happen in the claim is important. Now, as we wrap up the episode, one piece of advice that you talked about as we were preparing for this is really advising your clients to help themselves a little bit.
Right. The judges in the system want to help people to help themselves. The doctors in the system want to help people to help themselves. I want to help people to help themselves too. I see this in the other attorneys too that defend cases, and I can see it sometimes with the adjusters. If you're doing what you're supposed to, if you're following all the doctor's orders, if you're following all the treatment that he tells you to do, if he tells you to lose weight, if he asks you to stop smoking, if you're doing all those things, you're going to be surprised how much more people are going to be happy to deal with you and want to help you in your case. If you're asked to go back to work by the doctor, let's say he says you can go back to work. If you try to go back to work at least, even if you can't do it, but at least try to go back to work knowing that you can't do it, you're going to sound a whole lot better in front of that judge by saying, I tried to go back to work, Judge. Now, if you tell the judge, I couldn't do it, Judge, I didn't even try, there's no sense in it. Well, there's always that question about whether or not you could. But if you do actually try, even if you can't, you can tell the judge, now I tried. And the judge, I think, will think higher of you and want to help you more if you at least try to help yourself. And not only is it in medical treatment and dealing with, going back to work, but, some people get injured and not going to be able to do that job anymore. If you go out and check some other jobs out and you try to work somewhere else, if you try to go back to school, if you try to learn a new trade, some of this can be paid for by workers' comp, but even to get that, it helps to have your foot in the door looking for those kind of things. And if you're trying to help yourself doing all those things, that's stuff that we can argue about in front of the judge and get you some extra benefits. I think it also helps your case out, too, because the judge thinks that you're not wanting to sit around. You're wanting to go on with life, and you're wanting to make the best you can of a bad situation. And those are the kind of people that the judges want to help. Everybody else does, too.
I mean, that just makes so much sense. I mean, so much of this still is human nature.
Right.
And make yourself a good, qualified claimant so that people, again, want to do what's best for you and want to give you that little extra help when they can. And that's just good. That's just great advice. Scott, I really appreciate your time. I mean, you've spent 35 years practicing workers' compensation. I mean, you've seen a lot of stuff during that career, and you've been able to help people through some pretty challenging situations. But all of this advice has really been borne out over hundreds and hundreds and hundreds of cases that have come across your desk and individuals, because it's not just about the paperwork, it's about the person that you help. If someone wants to contact you, what would be the best way for them to get in contact with you these days?
The best way is to call my phone, which is 502-937-5287. And even if it's after hours, leave a message, we'll get back with you. That's the best way. We also have a website, ScheynostLaw.com, ScheynostLaw.com, and we have a contact form on there. You can fill that out and send that to me. And my email is sscheynost@ScheynostLaw.com. You can send me an email. If you want to fax us something, 888-270-6527. I'm happy to take a fax. You can drop something off at our office, too, 7619 Dixie Highway, Louisville, Kentucky. We're happy to talk to you. If you can't tell, I like to talk, so I'm happy to go over your case with you. Like I said before, we handle these on a contingency fee basis, which means there's no charge for calling me. We only charge you if we get money for you. Of course, we have to pay some money for expenses that you may have to reimburse for. But the call's generally free, and we're not going to charge you anything unless we get you something as far as attorney's fee.
That's outstanding. And friends, if some of that information raced past you in the show notes, which would be all the paragraphs of information below the actual recording, you'll find a link to Scott's website. You'll find the office phone number and some of the other information. I'll even put a link in there to that form that we talked about early on for the expenses to make it easy for you. But once again, Scott, I know you're busy. I really appreciate your time, and always good to see you, my friend.
Oh, I've enjoyed this. Thank you.
Take care. Bye-bye. Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's SCHEYNOST Law.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.